Well, a teen girl has been found guilty of manslaughter in the deadly group attack on a homeless man downtown.
The girl, who was 14 at the time of the attack, had originally been charged with second-degree murder in Kenneth Lee's death. Today, this afternoon, a judge found the teen not guilty of second-degree murder, saying he wasn't convinced beyond a reasonable doubt that the girl had the state of mind required for murder. The 59-year-old Lee was swarmed and attacked in a downtown parkette in 2022. 7 of 8 girls arrested in the case pleaded guilty to lesser charges. And for more on this development, we're joined live now by criminal defense lawyer Lydia Riva. Thank you so much for joining us, Lydia. It's good to see you. So this teen girl was found not guilty of murder. Does that surprise you?
It doesn't, in the sense that the mens rea for murder is that the Crown has to prove beyond a reasonable doubt that the accused had the intent to kill or the intent to cause bodily harm that she knew would likely cause death and be reckless of that. The state of mind for manslaughter, however, is less. It's the intent to commit an unlawful act, in this case an assault, and the assault has to be objectively dangerous. So it is a high burden, proof beyond a reasonable doubt, and the trial judge found that the Crown had not met its very high burden in this case.
Okay, so Ms. Riva, there are other defendants right here. Their fate is still up in the air. How will this impact what happens in those cases, or will it?
If the defendant in this case was somehow called against them to testify, that could make an impact. The trial judge in this case was considering the particular mental element or the mens rea of this defendant. And so in that sense, the triers of fact in the other cases are going to have to make the same determinations about those defendants, whether or not they had the state of mind for murder or manslaughter.
Bakari just brought up the other girls charged with swarming Kenneth Lee. Are we ever going to see anybody found guilty of actually stabbing him?
That I don't know. I know that in this case, the defense had raised the fact that the Crown could not prove that this accused person had done the stabbing. It's not uncommon in cases, especially when there's more than one defendant, in this case, a swarming or an alleged swarming, that we're never going to really know the answers to those questions. But this accused person is going to be held accountable. She is going to be sentenced, and she's convicted of a serious offense, which is manslaughter.
And, when this happened, we're talking about minors here. So let's talk about the sentencing, youth sentence versus adults, especially with respect to the victim's family.
The Crown policy is that in the case of murder and manslaughter, the Crown must seek an adult sentence unless they get special permission not to. And the difference between an adult sentence and youth sentence is significant in the case of manslaughter. In the case of manslaughter for a youth, maximum sentence is 3 years. But for an adult, it's life in prison. So it's quite a discrepancy. In order for the Crown to pursue an adult sentence, they have to bring notice before the arraignment of the defendant. And those are significant. That's a significant sentence, obviously, life in prison or an adult sentence for manslaughter, if that, in fact, is the finding.
Okay, criminal defense lawyer Lydia Riva, good to get your perspective on this and your expertise. Thanks so much for joining us tonight.
Thanks a lot.
Thank you.